Today, we confront a question that slices through headlines and diplomatic sound bites. Did the United States just cross a legal red line at sea? Over the past month, the US military has conducted 3 deadly strikes against small vessels in the Caribbean. The Pentagon claims these boats were narco-trafficking craft linked to Venezuela's powerful Tren de Aragua gang. The result? At least 14 people killed, including 3 men in the most recent incident. In Washington's framing, these were precision operations against criminals threatening US security. In Caracas' view, this was nothing short of an undeclared war, and in the eyes of human rights observers, it might be extrajudicial execution on the high seas. The stakes are high. If America's actions are deemed unlawful, this is not just another drug war story. It's a case study in how the world order bends or breaks under pressure. Let's first map out what happened. In early September 2025, US Southern Command confirmed its first strike, destroying a small craft allegedly transporting narcotics. 11 people reportedly died. In mid-September, a second incident unfolded, again targeting what officials described as a Venezuelan gang-linked smuggling vessel. Casualty numbers remained vague, but US media cited at least several deaths. On September 19th and 20th, the third strike came, killing 3 men aboard another vessel. Washington described it as a surgical hit on narco-terrorists. These operations are notable for their military character. Traditionally, US counter-narcotics in the Caribbean have relied heavily on the Coast Guard, which uses interdiction, boarding, and arrest tactics. Here, however, we saw combat aircraft and naval firepower obliterating small craft in open waters. What is less clear is where exactly these strikes happened. Pentagon releases vaguely describe them as being in international waters within Southcom's area of responsibility, which stretches across vast zones of the Caribbean and Latin America. For Venezuela, that vagueness fuels suspicion. The Maduro government insists the US is striking near its territorial waters, violating sovereignty and escalating toward confrontation. The heart of the debate lies in this: which body of law governs these incidents? There are 2 possible tracks. Peacetime maritime law enforcement, rooted in treaties like the UN Convention on the Law of the Sea, UNCLOS, and the 1988 UN Drug Convention. These rules envision cooperation, boarding, and due process, not aerial bombardment. The law of armed conflict, LOAC, which applies if a situation qualifies as an armed conflict under the UN Charter or customary international law. In that case, lethal force may be justified against hostile combatants. Most experts argue that drug trafficking, even by violent gangs, does not rise to the level of armed conflict. These are criminal operations, not military enemies. If that's true, the relevant framework is peacetime law enforcement, where the threshold for using lethal force is far higher. Let's unpack what those frameworks say. UNCLOS, Article 108. States are obligated to cooperate in suppressing illicit drug trafficking by sea, but they can't just storm or strike any vessel they choose. On the high seas, a ship generally falls under the exclusive jurisdiction of its flag state, the country whose flag it flies. The exception, if a ship is stateless, meaning it doesn't sail under any nation's flag, it loses that shield. Then, under international law, other states may board or seize it. The 1988 UN Drug Convention builds on this. It encourages states to interdict drug vessels, but only through boarding, searching, seizing, and arresting. The language is clearly law enforcement oriented, not military. In practice, this means the US has legal tools to go after drug traffickers at sea, but those tools look like Coast Guard chases, flag state consent agreements, and prosecutions in court. They do not look like missiles raining down on speedboats. This distinction matters. Lethal force at sea under law enforcement rules is only justified under necessity and proportionality. For example, if traffickers fired on US ships and posed an imminent risk to life. So far, no such evidence has been publicly presented. To understand why scholars are alarmed, consider precedent. In 1999, the International Tribunal for the Law of the Sea, ITLOS, ruled in the MV Saiga No. 2 case that force during maritime interdiction must always be necessary, reasonable, and avoid endangering human life. Firing on vessels recklessly is not just disproportionate, it's illegal. In another dispute, Guyana versus Suriname, 2007, the tribunal held that threatening the use of force in maritime disputes could violate the UN Charter's prohibition on the threat or use of force. What these rulings show is that maritime law enforcement is not a blank check. Even when states chase smugglers or violators, they are expected to act like police, not combatants. The US strikes, by contrast, appear to blur that line, applying war-style tactics in what is legally a law enforcement setting. So how does Washington justify its actions? The Biden administration, and now the Trump administration in office, has cited Article 2 of the US Constitution, the president's authority to act in self-defense to protect American interests and lives. A war powers notification sent to Congress framed the first strike as a self-defense operation, not a law enforcement one. Officials also used the language of narco-terrorism by linking Venezuelan gangs to terrorism and suggesting they pose imminent threats to Americans. They aim to justify treating traffickers as military targets. Critics aren't convinced. Human Rights Watch and regional experts argue that drug trafficking, no matter how violent, doesn't meet the threshold of an armed attack under Article 51 of the UN Charter. Without clear evidence of an imminent threat to US lives, these strikes look like extrajudicial executions and potential breaches of international law. Caracas, for its part, calls the strikes state terrorism and has lodged complaints at the United Nations. One of the few legal arguments the US can lean on is the issue of stateless vessels. Under international law, if a boat is truly stateless, that is, it sails without valid registration or a flag, then no state claims jurisdiction over it. In those cases, any state may board, search, and seize it. This principle is grounded in both customary maritime law and reflected in UNCLOS. But here's the catch. Stateless does not mean kill at will. Even in cases where US authorities have seized narco subs in the Pacific or Caribbean, the standard procedure has been boarding and capture, followed by criminal prosecution in US courts. Using lethal force from the outset, obliterating a vessel without warning, tests the very boundaries of this rule. For the US to argue legality, it would need to prove that the boats were genuinely stateless, that they posed an imminent threat to life, and that no lesser means, such as disabling or boarding, were available. So far, none of that evidence has been made public, and without transparency, the stateless loophole looks more like a grey zone exploited for convenience rather than a solid legal foundation. To understand why these strikes are raising eyebrows, we need to compare them to normal US counter-drug operations at sea. Traditionally, it's the US Coast Guard, not the Pentagon, that leads interdictions. The Coast Guard operates under Title 14 Law Enforcement Authority and has built an extensive network of shiprider agreements with Caribbean nations, allowing them to board vessels with flag state consent. The Coast Guard's methods are law enforcement in nature, hailing suspicious craft, pursuing them, firing disabling shots if necessary, then boarding and arresting. The hallmark is due process. Suspects face charges in federal courts, not missiles from fighter jets. By shifting these missions into the hands of US Southern Command, the government is bypassing that law enforcement model. Instead of Coast Guard cutters hailing traffickers, we see Department of Defense aircraft and warships firing lethal ordnance. This is not just a tactical choice, it's a policy rupture. Critics argue it erodes the line between policing crime and waging war, creating a dangerous precedent. If the military assumes a lead role in counter-narcotics, the world may interpret it as America sliding into a militarized drug war with no clear legal mandate. The controversy doesn't end at international law. Inside Washington, the strikes have triggered a fight over the War Powers Resolution. The administration's justification rests on Article 2 of the Constitution, which allows the president to act in self-defense without congressional approval. A War Powers notification described the first strike as a limited and necessary action against an imminent threat. But lawmakers from both parties, including Senator Tim Kaine and Representative Adam Schiff, argue that repeated lethal operations in the Caribbean constitute hostilities and thus require explicit congressional authorization. They warn that the president is stretching self-defense powers to cover actions that look more like offensive military strikes. Some lawmakers have already introduced resolutions to curb unilateral uses of force and demand greater oversight. This raises an uncomfortable question. If even the US Congress doubts the legal basis of these strikes, how will the rest of the world view them? Human rights advocates have been scathing. Human Rights Watch described the killings as unlawful extrajudicial executions. They argue that suspects, no matter how violent or criminal, are entitled to due process under peacetime law enforcement frameworks. Other analysts note that the UN Charter's Article 2.4 prohibits the use of force, except in two circumstances: Security Council authorization or self-defense against an armed attack. Drug trafficking, they stress, does not equate to an armed attack. Unless the US can show these vessels were actively preparing an imminent assault, not just transporting narcotics, the self-defense claim remains shaky. The danger is clear. If every state begins using narco-terrorism or criminal activity as grounds for military strikes, the international order risks a slippery slope where law enforcement becomes indistinguishable from armed conflict. The strikes are already reshaping geopolitics in the Caribbean. Venezuela has launched military exercises near the strike zones, mobilizing militia units and calling the US actions state terrorism. Caracas has demanded a UN investigation, framing the attacks as violations of sovereignty and international law. Neighbouring states are caught in the middle. Many cooperate with the US on counter-drug missions, but fear being drawn into an escalating conflict. This tension risks creating a Cold War-style standoff in the Caribbean, with maritime patrols and surveillance flights becoming flashpoints for confrontation. So, where does this leave us? Internationally, the strikes risk violating the UN Charter UNCLOS and the 1988 UN Drug Convention. Unless the US proves imminent threats and necessity, it faces accusations of acting illegally. Domestically, the president's reliance on Article 2 authority is shaky. Repeated lethal actions without congressional approval risk breaching the War Powers Resolution. Diplomatically, America's credibility takes a hit. If the US bends the rules to justify lethal force at sea, it weakens its ability to demand compliance from rivals like Russia or China in their maritime operations. At the same time, Washington insists the strikes are both legal and necessary, part of a broader campaign to dismantle transnational criminal organizations that threaten US security. So, legal or illegal? On the facts we know today, the answer tilts toward illegality under international law and, at best, a murky justification under US domestic law. Without transparency about flag status, imminence of threats, or why missiles were chosen over boarding, Washington struggles to make its case. This isn't just a narrow legal debate. It's about the future of maritime governance. If the line between law enforcement and warfare blurs, we risk a world where powerful states use military strikes to police the seas, bypassing due process and international oversight. For Venezuela, the strikes are a violation of sovereignty. For the US, they are a bold assertion of self-defense. For the world, they are a test. Do the rules still matter when superpowers act unilaterally? So here's the takeaway. Whether you call them narco-boats or stateless vessels, whether you frame it as law enforcement or war, the United States has entered dangerous waters. And until the evidence is on the table, the world will keep asking, legal or illegal?